A while ago, we told you that the Nigerian Senate had responded to Senator Natasha Akpoti-Uduaghan to stay clear of the National Assembly, insisting that she cannot resume duties just yet, despite a federal high court in Abuja demanding that she be reinstated as a senator of the Federal Republic. So to help us make sense of this, basically to put it in a proper legal perspective, I'm joined by a legal practitioner, Elvis Asia. Elvis, thank you so much for joining us on the news.
Thank you for having me on the news.
Now, first, we need to put this to bed. Did Justice Binta Nyako of the Federal High Court order or advise the Nigerian Senate to reinstate Senator Akpoti-Uduaghan?
Quite frankly, you know, it's unfortunate that we are even asking that question. Looking at the judgment, it's quite difficult to say either way. There were no injunctive orders made to compel the Senate to reinstate Senator Uduaghan. But however, the court actually made, you know, findings to the effect that suspending her for that length of time, for 6 months, was excessive, was not in line with the intention of the Constitution, and therefore, you know, decided that the court believes that the Senate should, I think that's the word used in the judgment, should recall the senator. Now, what that means is that, you know, even if there was a possible order that the Senate should recall her, the Senate will have to make that decision, or they have to take that step to recall. And if the Senate fails to do that, there are legal mechanisms for seeking to enforce the positive order of court. And I don't think self-help is one of them. Going to the Senate to say you want to resume, I don't think that is going to be one of the ways by which you can enforce a judgment, particularly when the judgment borders on recall. So there has to be an action on the part of the Senate recalling the senator.
Did you say?
Because if
well, actually, deducing from what you're saying now, it seems as though the Justice Nyako's ruling was vague. And now that the Senate is insisting that no valid court mandated the senator's immediate recall, then this would basically mean that there's no flagrant disobedience of a court ruling.
Well, I mean, decision is quite frankly, you can use that word vague, because when you are reading at a point, you think that this is what the court is saying. On that level, you begin to see something different. But what I can see from the judgment is that the judge indeed made a finding that it was excessive to have suspended her for 6 months. And in fact, the court said that the rules of the Senate that allows such a suspension for that length of time was unconstitutional, or considered unconstitutional. So the court made that finding. And the court also said that the court believes that she should be recalled. So the Senate, in my view, under that judgment, has an obligation to recall the senator. And if the senator if they fail to do so, the senator, has lawyers. They know what to do, legally speaking, to compel the Senate to act in accordance with the judgment. There is no decision there's nothing in the judgment that says that she should just go and resume. What is suggested in the judgment is that the Senate should recall her. So the Senate ought to do so. And if the Senate is saying, for example, that they have appealed, or the other party has appealed, or there's an application for stay, preventing them from complying with the directive for recall, I will understand it. But in the absence of any order of court, putting a suspension on the judgment, as it stands now, the Senate ought to recall the senator.
Okay. Now that you're based on the judgment. All right, Elvis, now that you are saying the Senate is obligated to recall the senator, and we understand that despite receiving a copy of the CTC, the Senate demanded that the senator should apologize and make payments of a fine handed over to her before adjudicating over that particular matter. So is it also binding on Natasha to also fulfill her own part of the conditions for a reinstatement, or should she probably continue with an appeal?
Oh, well, I mean, I don't think that apologizing was a condition for for the recall. Yes, there is also an obligation on Natasha to apologize to the Senate, like the court has ordered. But my understanding is that that part of the judgment has been appealed, and it's probably contested. But like I said earlier, which also applies to the senator, if there is no express application pending to stay or an injunction pending appeal, then the judgment is what it is. She should honorably, by virtue of the judgment, go ahead and apologize. The Senate has an obligation to recall her. But I don't think it's not conditional on the recall that the court ordered. If the Senate wants to enforce the apology, then they also know what to do. It's not something that they should be doing on the pages of the newspaper or through press releases. But they are obligated, because the court was very mindful of the fact that you are denying a senatorial district of representation. And that's the perspective from which the court came to the conclusion that it was inconstitutional constitution to suspend her for that long. So the more they continue to delay this recall, the more they are denying the people that she represents of representation, which they are entitled to under the Constitution. Yes, the court reasoned that you have the right to discipline, but your discipline must not be excessive. If the Senate is meant to sit for 181 days in a year, and somebody is suspended for 6 months, which is about 180 days, that is excessive. That's the whole essence of the decision. So yes, she ordered the judgment of the court. She should apologize, but like I said, she has appealed against it, and she's seeking to prevent that apology. Then she may be excused until the court determines otherwise. So also in the Senate has appealed the part of the judgment asking that she should be recalled, and there's also an application for stay. Then that decision will also wait until the court determines it. But in the absence of any such an application from both sides, then they are bound by the decision as it is today.
Now, Elvis, we understand the interdependency and, of course, the independence of these layers of government. Now, the Senate, according to its standing rule, said that there is no specification on how many days or hours a senator can be reprimanded, and they solely have the discretion to decide how many days or months or years, as the case may be, that they would hand down the punishment to an erring Senate. So invariably, this would mean that there is no one that would hold the Senate to a fault if they decide to continue with the suspension for 180 days.
No, but I mean, the court has already said that they could not, suspend for that long. The court discipline, but your discipline must not be excessive. It must not be done in such a manner as to deny a constituency of their right to representation in the Senate. So they don't have that. It's not. They don't have the right to extend suspension for this long. And that's the decision of the court. So already that provision in the rules of the Senate has been interpreted to mean that it cannot be excessive, which means you cannot, and the court specifically said that 6 months was excessive in this particular instance. So they don't have that discretion to extend it, ad infinitum or forever. They must do so in line with the constitutional provision that allows a constituency to be represented. Because what we are seeing here is beyond just Natasha. Because what it means is that somebody a constituency a senatorial district can send somebody to represent them at the Senate, and the powers that be at the National Assembly or in the country can deny that senatorial district of representation through some form of discipline. I mean, if you want to do the discipline, you can say, okay, 1 week, a few days, or whatever. But to say that somebody should not come to the Senate for 6 months, the court has said is excessive. So the Senate does not have the right to continue to extend it. As it stands today, they have no power to suspend somebody for 6 months. And that's what the decision of the Justice Nyako is actually saying. That you shouldn't be able to suspend, because it will be inconstitutional with the Constitution. And the court even directed that they should go and amend that rule so that they can put a limit to it. It shouldn't be at large as it is now. That power to extend it, to make it at large under the rules, which is obviously a political tool, has been cut to size by the court. And it's unfortunate that the Senate is not seeing it from that perspective and respecting, the details. Because, I mean, yes, separation of powers must be in line with the Constitution. So, yes, you have the right to determine your own rules and whatever it is. But when you do so in a manner that, is excessive and denies a whole senatorial district of representation, then the court can come in. That's what the court has done in this case.
Well, you earlier admitted that the justice, or rather the ruling handed down, was vague. One would have thought that if it was explicitly clear, then it would have made more meaning in terms of its implementation, let's say interpretation too. So as a legal luminary, the Senate is insisting that Natasha completes her suspension. If you were a legal counsel, what would you advise?
Well, as it stands today, the Senate has no power. They don't have no right to say she should complete the suspension, right? So what, I mean, I'm sure the lawyers are thinking of what to do. What they should do is obviously to approach the same court. There are ways to enforce an order or directive or decision of court. And I mean, we cannot sit here and pretend to want to school anybody on what to do. And I'm sure the lawyers, very senior lawyers, they will take the appropriate steps at the right time. But what I'm saying is that going to the National Assembly to resume on your own is not really the legal way to do that. That may also just occasion further chaos and all these social media cycles that we have seen, on a serious matter such as this. There are legal mechanisms I believe lawyers will explore, and they know it. They should explore that rather than resorting to self-help in doing so.
Thank you so much, Elvis Asia, for sharing your legal perspective with us on the news.